Okay, let's unpack this. You open that mailbox here in California and bam, there's a formal 30-day notice to move out.
Right.
That immediately creates like a knot of uncertainty in your stomach, doesn't it?
Really big.
That feeling of, wait, what does this actually mean for me? That's exactly what we're digging into today.
Exactly. This deep dive is all about getting a handle on that 30-day notice to vacate. Specifically for California tenants, month to month, less than a year in the place.
Right, that specific situation.
Yeah.
And to guide us, we've pulled together some really crucial info from legal guides, court resources, tenant rights stuff.
And we're also bringing in the perspective of the Martinez Law Center. They're really focused on tenant rights. You can check them out at martinezlawcenter.com.
Good resource. So our goal today really is just to arm you with clear, practical knowledge. Your rights, the proper steps for a 30-day notice, cut through the confusion.
Yeah, exactly. Make sure you have a solid understanding. No surprises, hopefully.
Okay, so let's get right to it. What is a 30-day notice, fundamentally, in this context?
Well, at its core, it's a formal written warning from your landlord saying they're ending your month-to-month agreement.
Specifically, when you've been there less than a year.
Yes, that's the key time frame here. And you should think of it as the official first step before any potential eviction process might start.
Okay, definitely something to take seriously then. Now, does the landlord have to give a specific reason, like why they're doing it?
This is interesting. For tenancies under a year in California, generally, no. Landlords aren't usually legally required to state a specific cause.
Really?
Yeah, as long as the reason isn't discriminatory, based on race, religion, that kind of thing, they typically have the right to end the agreement with this notice.
Okay, so no cause needed as long as it's not illegal discrimination.
Exactly. And that's a big difference compared to when you've lived somewhere for a year or more. In those cases, for no fault reasons, they usually need to give a 60-day notice.
Got it. So under a year, 30 days, often no stated reason needed. Over a year, usually 60 days, and different rules apply.
Pretty much, yeah.
Now, if you get one of these 30-day notices,
yeah,
what's the absolute number one most critical thing to look for first?
Oh, hands down, it must be in writing. Absolutely must be.
No wiggle room there, like a call or a text doesn't count?
No, not at all. Verbal notice, phone call, text message, even an email. It just does not meet the legal standard in California for a notice to vacate.
Wow.
If it isn't a formal written document, legally, it doesn't carry weight for starting that eviction clock.
That seems so basic, but I bet it gets missed sometimes in the panic.
It can, yeah. People might just react to the message itself.
Okay, so you've got the written notice.
Yeah.
How do you figure out the deadline? When do those 30 days actually run out?
Right, the timeline is crucial. The 30 days start counting the day after you receive the notice.
The day after?
Yes. So if it shows up on, say, the 5th of the month, day one of the 30 days is the 6th.
Okay. And is it just 30 calendar days straight, like weekends included?
For a notice to vacate like this, yes, you generally count 30 consecutive calendar days. But there's a small, helpful detail. If that 30th day lands on a Saturday, Sunday, or a court holiday, then your actual deadline gets pushed to the next business day.
Oh, that's good to know.
It is. It's a bit different from, say, notices to pay rent, where weekends and holidays might be excluded differently in the initial count. But for vacating, it's usually consecutive days with that weekend holiday extension at the end if needed.
Okay, that's a really important detail. Now, you mentioned reasons earlier and just cause. Does that concept pop up at all with these 30-day notices for shorter tenancies?
Good question. Generally, just cause eviction laws, the ones that require a specific legal reason from a list, those mainly apply to tenancies that have lasted a year or longer in California.
So for our situation, month to month, under a year, just cause isn't usually part of the equation?
Typically, no. For a standard 30-day notice in this scenario, the landlord doesn't need a specific just cause reason from those statutes.
But you said.
But, and this is vital, the reason still can't be discriminatory. They can't ask you to leave because of your ethnicity, family status, disability, anything like that. That's always illegal.
Right, okay. So no specific just cause from the list needed generally, but discrimination is absolutely forbidden.
You got it.
Now, let's talk about actually getting the notice. The landlord has this written paper. How do they legally have to give it to you? Can they just slide it under the door?
Service. Yes, this is super important and where mistakes can happen. Proper legal service is a must. California law outlines 4 specific acceptable ways.
4 ways. Okay, let's break them down. What's number 1?
Number 1 is the most direct personal service. Someone, the landlord or an agent, has to be over 18, physically hands the notice directly to you, the tenant.
Okay, hand to hand. Simple enough. Method 2.
Method 2 is substituted service. This is if they can't find you to hand it to you personally after trying.
Okay.
They can give a copy to another adult again, 18 or older, either at your home or where you work, but that's not all.
Right, there's more.
Yes, they also have to mail a copy of the notice to your address. And here's the kicker. The 30-day clock doesn't start until the day after they mail that copy.
Wow, okay, so handing it to someone else and mailing it. And the mailing date is key for the timeline.
Exactly. It ensures you actually get notified, not just someone else at the address.
Makes sense. What's method 3?
Third is posting and mailing. Similar idea, if they can't serve you personally, they can post a copy in a visible place on the property, usually the front door.
Like taping it to the door.
Yeah, pretty much. But just like substituted service, posting alone isn't enough. They must also mail a copy to your address.
And the clock starts after mailing again.
You got it. Day after the mailing day.
Okay, so mailing is crucial for both substituted and posting methods. What's the last one, number 4?
The fourth way is using registered or certified mail with a return receipt requested. This gives the landlord proof from the post office that it was sent and someone signed for it at your address.
Okay, those are the 4 official ways. Now, what about common mistakes? Ways landlords try to serve it that aren't actually legal.
Oh yeah, happens all the time. A big one is just sending it by regular first-class mail.
Just dropping it in the mailbox.
Exactly. That doesn't count as proper service under the law for this type of notice. Neither does just sending an email or a text message.
So if that's all you get, regular mail, email, text, it's technically not valid service.
Correct. Legally, it's insufficient. And one more thing. Whoever actually does the serving, personal, substituted posting, they should fill out a proof of service form.
What's that?
It's a document where they detail exactly how, when, and where they served the notice, and they sign it under penalty of perjury, basically swearing it's true.
Wow, okay. So the delivery process is really quite specific and formal. What if the landlord messes this up? If they don't use one of those 4 methods correctly?
Big consequences for the landlord, potentially. If they try to move forward with an eviction lawsuit in court based on improperly served notice, the court is very likely to just dismiss the case. Throw it out.
Seriously, just dismiss it.
Yes, because you weren't legally notified according to the rules. The judge will probably say the process is invalid.
So what happens then?
The landlord has to start all over again, prepare a new notice, serve it correctly using one of the 4 methods, and the 30-day clock restarts. It means delays for them and more time for the tenant.
That's huge.
Yeah.
Knowing about proper service seems really critical for tenants. Okay, let's shift. You get a 30-day notice. It looks like it was delivered properly. What are your immediate options? What should you do?
Okay, first step. Read it carefully, understand the deadline. Then you generally have a few paths. One is to comply. Start planning your move, find a new place, and be out by the date.
Right, the straightforward path. What else?
Talk to your landlord. Communicate. You can ask questions, maybe understand the reason, even if they didn't have to state one. Sometimes discussion can lead to maybe more time or some other arrangement. It doesn't hurt to ask.
Good point. Open communication. What if you disagree with the notice or you just physically can't move in 30 days?
Okay, if you don't move out by the deadline, and you haven't worked anything out with the landlord, you need to understand what comes next.
Well,
the landlord will likely file an unlawful detainer lawsuit. That's the formal court process for eviction.
and that's where things get serious, legally speaking.
Very serious. Which brings me to probably the most important piece of advice.
What's that?
Get legal help immediately. As soon as you receive any eviction notice, a 30-day included, talk to a lawyer who knows tenant rights.
Why so critical?
They can review everything, the notice, the service, your lease, the situation. They can tell you if the landlord messed up, what your defenses are, what your best options are. It's crucial. And for folks in Orange County, LA, Riverside, San Diego, Martinez Law Center, martinezlawcenter.com, that's what they do. They only represent tenants in these cases.
Okay, so key message. Don't wait. Get professional advice right away. martinezlawcenter.com for those specific counties. Now, what about those horror stories? Landlords changing locks or shutting off power? Is that ever legal?
Absolutely not. Never. In California, a landlord cannot legally force you out themselves. Only a court order can lead to eviction.
So no self-help evictions.
0. Changing locks, cutting utilities, removing your stuff that's illegal, it violates your rights significantly.
What happens if a landlord does try that?
They can face serious legal trouble, including being sued by you, the tenant, Even if they win an eviction lawsuit in court, they still can't physically remove you.
Who does then?
Only a law enforcement officer, usually the sheriff, acting with a specific court order called a writ of possession, can legally remove a tenant.
Okay, good to know the proper process involves the courts and law enforcement, not the landlord taking direct action.
Right.
Let's talk security deposits. You're moving out because of this notice. What about getting your deposit back?
Right, the deposit. You actually have a right to request a pre-move-out inspection. A pre-move-out inspection. Within the last 2 weeks, before your move-out date, the landlord walks through with you and points out things they might deduct for, like damage or cleaning needed.
Why is that helpful?
It gives you a chance to fix those things yourself before you leave, potentially avoiding deductions from your deposit. It's a heads up.
Smart. Okay, so you do that, you move out. Then what happens with the deposit money?
The landlord has 21 calendar days after you've completely vacated to do one of two things. Either return your full deposit or return whatever is left, along with a detailed, itemized statement.
Itemized statements.
Yes, listing exactly what they deducted for and how much each item cost. They can't just keep money without explaining why in writing.
And what are the valid reasons they can deduct for?
It's pretty specific. Unpaid rent you still owe. Repairs for damage beyond normal wear and tear, things you actually broke or damaged unreasonably.
Okay, not just regular use.
Exactly. Also, necessary cleaning costs to get the unit back to the same level of cleanliness it was when you moved in. Again, minus normal wear and tear. And finally, if they provided furniture, costs for damage or excessive wear to that.
What about, like, faded paint after 5 years? Or carpet getting thin in walkways?
Generally, no. That usually falls under normal wear and tear, which is the landlord's responsibility. They can't charge you for the property just aging naturally through normal use.
So how do you protect yourself if there's a disagreement about wear and tear versus damage?
Photos, videos, document everything. Take detailed pictures or video of the condition when you move in and do it again right before you hand over the keys when you move out. That visual proof can be invaluable if there's a dispute later.
Excellent practical tip. Okay, one more scenario.
Yeah.
You move out, but oops, you accidentally leave a box of books or something behind. What happens then?
The landlord can't just toss it immediately. They have a legal duty here. They need to notify you in writing that you left personal property behind.
Notify you how?
They need to give you formal notice and tell you where the property is stored and that you have a certain amount of time to come get it.
How much time?
Usually it's a minimum of 15 days if they give you the notice personally, or 18 days if they mail the notice to your last known address.
Can they charge you for keeping your stuff during that time?
Yes, they can charge reasonable storage costs. So it's best to contact them ASAP if you realize you left something. The quicker you arrange pickup, usually the less it will cost you, if anything.
And if you don't claim it within that 15 or 18-day window?
Then, depending on the value of the property, the landlord generally has the right to dispose of it, sell it, keep it, or throw it away, following specific procedures.
Okay, so again, communication and acting fast is key there. We've covered a lot about landlord duties and tenant rights. If you feel your landlord didn't follow the rules, bad notice, illegal eviction attempt, what can you actually do?
Well, if you believe the notice was improper or your rights were violated in some way, that can be a strong defense if the landlord files that unlawful detainer lawsuit against you.
You can fight the eviction in court based on that.
Absolutely. You have the right to present your side, explain why the eviction isn't lawful, maybe because the notice was defective or they tried an illegal lockout. These are valid defenses.
And navigating court sounds daunting. Where can people find help?
Legal aid is a great starting point. Many organizations across California offer free or low-cost help to eligible tenants facing eviction. They can guide you through the process.
And specifically, again, for our listeners in Southern California.
Yes, for tenants in Orange County, LA County, Riverside, San Diego, Martinez Law Center is dedicated solely to representing tenants in unlawful detainer cases. If you're in that situation in those areas, definitely check out martinezlawcenter.com. They understand these issues inside and out from the tenant's perspective.
That's a really important resource. Okay, let's try to boil this down. Key takeaways from today about that 30-day notice in California for under a year tenancies.
Number 1, gotta be written notice. Number 2, gotta be served properly. Those 4 specific ways. Number 3, understand the timeline, know your rights about the security deposit, and what happens with abandoned property.
And knowing these things can make a huge difference.
Absolutely. The goal here was to make you feel more informed, more prepared if you ever face this. Knowledge is power in these situations. And remember, the absolute best thing you can do if you get any eviction notice is seek legal advice right away. Don't delay.
For sure. And again, for tenants in Orange, LA, Riverside, San Diego counties, MartinezLawCenter.com is a resource focused just on your rights.
Exactly.
So here's something to think about as we wrap up. In California's complex housing landscape, understanding your rights isn't just about one notice. It's about realizing the power that comes with being informed. Knowing the rules, knowing where to turn for help, like legal aid or specialized firms like Martinez Law Center.
Yeah.
It helps level that playing field, doesn't it?
It really does.
So the question for you, the listener, is how can you proactively stay informed about your rights as a tenant here in California, even before a notice ever arrives? What steps can you take?
Call now 714-442-9741. Thank you.